Imagine waking up tomorrow to learn that the Supreme Court has just agreed to hear the case that could permanently end every single so-called assault weapon ban in America. That's not a fantasy anymore. That is now becoming a very real possibility. And the news that we got this week could change everything for the Second Amendment and for gun rights in this country. So let's talk about what just happened at the Supreme Court, what this means for these challenges going forward, and why this could be the most important Second Amendment case since Bruin. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, double check to make sure YouTube has not unsubscribed you. We've been seeing a lot of that happening lately, so just make sure you're still subscribed. And also, I want to thank the main supporters of this channel. Your support allows us to keep bringing you this critical Second Amendment content, and I really appreciate it. In this video, we're going to be discussing breaking news from the Supreme Court regarding multiple rifle and magazine ban challenges that could fundamentally reshape gun rights in America. And we're going to talk about what happened, why it happened, and what comes next. The primary development that I want to talk about is what occurred at the Supreme Court's most recent conference. And this involves not just one case, but multiple cases that are all challenging these so-called assault weapon bans and magazine capacity restrictions. The two main cases that we're going to focus on are Vamonte versus Cook County, which is the Illinois rifle ban challenge, and Duncan versus Bonta, which is the California magazine ban challenge. Both of these cases have been moving through the system, and both of these cases just took a significant step forward at the Supreme Court. And here's why this is absolutely massive. For decades, the term assault weapon has been the most polarizing phrase in American politics. But as of February 2026, the legal gears are turning at a speed we haven't seen in a generation. Now, here's what you need to understand about how the Supreme Court works when it comes to deciding which cases they're going to hear. Every week during the Supreme Court's term, the justices meet in what's called a conference. And at these conferences, they discuss which petitions for review they want to grant and which ones they want to deny. The vast majority of cases that come to the Supreme Court get denied. In fact, the Supreme Court receives thousands and thousands of petitions every single year, but they only grant review to a tiny fraction of those cases, usually somewhere between 60 and 80 cases per term. So getting the Supreme Court to take your case is extremely difficult. But here's where things get interesting. Sometimes when the Supreme Court is considering a case, they don't immediately grant it or deny it at that first conference. Instead, they relist the case for another conference. And this is where the analytics and the data become extremely important, because what the data shows us is that cases that get relisted have a significantly higher chance of being granted review than cases that are just immediately denied at that first conference. So when a case gets relisted, that's actually a very good sign. It means the justices are seriously considering taking the case. It means they're discussing it, it means they're debating it, and it means that at least some of the justices think this case is worthy of the Supreme Court's attention. Now let's talk about what just happened with these rifle ban and magazine ban cases. Both Vamonte versus Cook County and Duncan versus Bonta went to Supreme Court conference recently, and instead of being immediately denied like so many other cases, both of these cases were relisted for another conference. That means the Supreme Court is actively considering whether to take up these challenges, and that is massive news, because for years now, gun rights advocates have been begging the Supreme Court to take up a rifle ban case or a magazine ban case and finally settle this question once and for all. Are AR-15s and standard capacity magazines protected by the Second Amendment? And for years, the Supreme Court has been punting on this issue. They've been avoiding it. They've been denying review to case after case after case. But now, something appears to be changing. The whispers in the halls of the Supreme Court are getting louder. From the historic Bruin decision to the recent sharp dissents from Justice Clarence Thomas, the writing is on the wall. The era of state-level semi-automatic bans is facing a terminal diagnosis. And to understand why a permanent end is being pushed forward, we have to look at the legal house of cards that supports these bans. Let me give you the background on these cases so you understand exactly what's at stake here and how we got to this point. Let's start with Vamonte versus Cook County. This case challenges Cook County, Illinois' ban on so-called assault weapons. Now, Cook County, which includes Chicago, passed an ordinance that makes it a crime to sell, transfer, or even possess certain semi-automatic rifles that the county has deemed to be assault weapons. This includes AR-15s, AK-47s, and similar firearms. The ordinance also bans magazines that hold more than a certain number of rounds. Essentially, Cook County has made it illegal for law-abiding citizens to own the most popular rifle in America. The plaintiffs in this case, which include individual gun owners and organizations like the Second Amendment Foundation, filed a lawsuit back in 2021 challenging this ban as unconstitutional under the Second Amendment. They argued that AR-15s are protected arms under the Second Amendment and that the county cannot simply ban them. Now, while this case was pending in the lower courts, the state of Illinois decided to go even further. In 2024, Illinois passed a statewide so-called assault weapon ban known as the Protect Illinois Communities Act, or PICA, and PICA essentially does at the state level what Cook County was already doing at the local level. It bans AR-15s and similar rifles across the entire state. Around the same time that PICA was being challenged in court, the Seventh Circuit Court of Appeals decided a case called Beavis versus Naperville, and in that case, the Seventh Circuit upheld Illinois' assault weapon ban. But here's the problem. The reasoning that the Seventh Circuit used was deeply flawed and directly contradicts what the Supreme Court has said about the Second Amendment. The Seventh Circuit essentially ruled that AR-15s and similar rifles are too militaristic to be protected by the Second Amendment. They said that because these firearms are useful in military service, they can be banned. Now, if you know anything about the Supreme Court's Second Amendment jurisprudence, you know that this reasoning is completely backwards. The Supreme Court has repeatedly said that the Second Amendment protects arms that are in common use for lawful purposes, and AR-15s are absolutely in common use. According to the latest industry reports, there are now over 28 million modern sporting rifles in the hands of American citizens. Why does that number matter? Because of a little thing called the common use test. When a state tries to ban the most common rifle in the country, they aren't just regulating a weapon, they are infringing on a core constitutional protection. But the Seventh Circuit went even further. They essentially said that the more useful a firearm is for militia service, the less it's protected by the Second Amendment. This turns the entire purpose of the Second Amendment on its head. The Second Amendment was designed to protect the people's ability to be armed and to serve in a militia if necessary. So saying that militarily useful weapons aren't protected makes absolutely no sense. It's like saying the First Amendment protects all speech except political speech, which is the most important kind of speech that the First Amendment was designed to protect. And here's where things get even more interesting. The Seventh Circuit and the Fourth Circuit have both recently tried to use a dangerous new logic. They claim that because an AR-15 looks like an M16, it is effectively a weapon of war and can be banned. But the Supreme Court is pushing back on this. The petitioners are using a brilliant strategy. They are pointing out what I call the cosmetic fallacy. Think about this. You can have two firearms that fire the exact same caliber, fire at the exact same rate, 1 round per trigger pull with identical capabilities. One has a wood stock and is legal in New York. The other has a black polymer stock and is a felony. The Supreme Court justices, specifically Thomas and Alito, have signaled they are tired of these games of appearance. You cannot ban a firearm based on how it looks if its function is identical to firearms that are legal. So the district court in the Cook County case was bound by what the Seventh Circuit said in Beavis, and as a result, the district court upheld Cook County's rifle ban and granted summary judgment in favor of the county. The plaintiffs then appealed to the Seventh Circuit, and in 2025, the Seventh Circuit affirmed the lower court's decision. The Seventh Circuit relied heavily on its prior decision in Beavis and treated AR-15s as essentially civilian versions of military M16 rifles, and therefore claimed they are outside the Second Amendment's protection. Now, the plaintiffs are asking the Supreme Court to step in and correct this. They're asking the Supreme Court to finally answer the question that lower courts have been struggling with and getting wrong. Does the Second Amendment protect AR-15s and similar semi-automatic rifles? And the answer, according to the text, history, and tradition of the Second Amendment, should be a resounding yes. These are arms that are in common use for lawful purposes. They are used by millions of Americans for self-defense, for sport, for hunting, and yes, for militia service if that ever becomes necessary. They are exactly the type of arms that the Second Amendment was designed to protect. Now let's talk about the other case that was relisted, Duncan versus Bonta. This is the California magazine ban challenge. California has a law that bans magazines that hold more than 10 rounds. So if you have a standard capacity magazine that holds 15 rounds or 17 rounds or 30 rounds, that's illegal in California. The plaintiffs in Duncan challenged this ban as unconstitutional, and initially they actually won in the lower courts. A district court judge in California struck down the magazine ban as unconstitutional. But then California appealed to the Ninth Circuit Court of Appeals, and in a decision that shocked many people, a 3-judge panel of the Ninth Circuit actually upheld the district court's decision and struck down the magazine ban. That was a huge victory. But then California asked for what's called en banc review, which means they wanted the entire Ninth Circuit to rehear the case, not just a 3-judge panel, and the Ninth Circuit granted that request. The unbanked Ninth Circuit then reversed the 3-judge panel and upheld California's magazine ban. The plaintiffs then asked the Supreme Court to take the case. And this is where things get interesting. The Supreme Court actually granted the petition, vacated the Ninth Circuit's decision, and remanded the case back to the Ninth Circuit for reconsideration in light of the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. Now, Bruin was the landmark Supreme Court case from 2022 that fundamentally changed how Second Amendment cases are analyzed. In Bruin, the Supreme Court said that when the government wants to regulate firearms, it has to show that the regulation is consistent with this nation's historical tradition of firearm regulation. The government can't just say the regulation promotes public safety or serves some important government interest. They have to show historical precedent for the regulation. So the Supreme Court sent Duncan back to the Ninth Circuit and essentially said, apply Bruin and get it right this time. But what did the Ninth Circuit do? They once again upheld California's magazine ban. The Ninth Circuit claimed that magazine bans are consistent with historical tradition. They pointed to some historical laws and regulations from the 1800s and early 1900s and claimed that these provided sufficient historical support for California's magazine ban. And here's the problem with that. In 2022, the court gave us the history and tradition test. They said if the government wants to ban a firearm, they have to find a historical analog from around 1791. In 2026, the government is failing this test miserably. What did they have in 1791? They had multi-shot flintlocks. They had the Girardoni air rifle with a 20-round capacity. They had private citizens owning literal cannons. What they didn't have was a government telling a citizen their rifle was too effective. The Supreme Court is currently reviewing these relisted cases because the lower courts are making things up. They are trying to say that 19th century laws against Bowie knives are the same thing as banning an AR-15. It's a legal reach so desperate it's almost laughable, and the justices are losing their patience. Many legal scholars and gun rights advocates looked at the Ninth Circuit's decision and said, this is wrong. The Ninth Circuit is not properly applying Bruin. They're cherry-picking historical examples and stretching them beyond recognition to justify a modern gun control law that has no real historical analog. So the plaintiffs once again asked the Supreme Court to take the case, and now Duncan has been relisted along with Vamonte. Both cases are being considered by the Supreme Court at the same time. And this is significant because it shows that the Supreme Court is potentially ready to address both the rifle ban question and the magazine ban question. These two issues are closely related. Many of the same states that ban AR-15s also ban standard capacity magazines, and many of the same legal arguments apply to both, so it would make sense for the Supreme Court to take both cases and address both issues together. While the Supreme Court has been hesitant to take a direct case on AR-15 bans so far, the pressure is mounting from the circuit courts. The Third Circuit is the one to watch. The full court is reviewing New Jersey's AR-15 ban, and legal experts suggest this may be the first appellate court to strike down such a ban in 2026. The Seventh Circuit is currently reviewing Illinois' Protect Illinois Communities Act. The Ninth Circuit recently upheld magazine bans in California, but the assault weapon ban case is still under active appeal, and the Fourth Circuit reaffirmed Maryland's ban in late 2024. Now let's talk about what it means that these cases have been relisted and what the data tells us about the likelihood of the Supreme Court granting review. As I mentioned earlier, when a case gets relisted, that's generally a good sign. It means the justices are taking the case seriously, but the data gives us even more insight. According to Supreme Court analytics from recent terms, specifically looking at the 2016 to 2020 terms, we can see some very interesting patterns. First, between 31% and 43% of petitions that were relisted at least one time were eventually granted review. That's a significant percentage. Compare that to the overall grant rate for all petitions, which is usually somewhere around 1% to 2%. So a case that gets relisted is many times more likely to be granted than a case that doesn't get relisted. Second, and this is even more striking, between 66% and 75% of all cases that were ultimately granted review had been relisted at least once. So the vast majority of cases that the Supreme Court decides to hear went through at least one relist. This tells us that relisting is often part of the process when the Supreme Court is seriously considering taking a case. The justices need time to discuss the case, to circulate memos, to consider the legal issues, and to decide whether the case is the right vehicle for addressing those issues. But here's the important caveat. One relist is good. Multiple relists are bad. The data shows that if a case gets relisted 2, 3, 4, or more times, the odds of it being granted actually start to go down significantly. Multiple relists often indicate that the case is going to be denied and that one or more justices is potentially writing a dissent from the denial or a statement explaining why they think the case should have been granted but wasn't. We saw this exact pattern play out recently with the Snope rifle ban case out of Maryland. That case was relisted multiple times, and each time it was relisted, those of us who follow these cases closely started to become more and more pessimistic about its chances. And sure enough, the Supreme Court ultimately denied review in Snope. So multiple relists are a warning sign. But one relist, which is where we are right now with Vamonte and Duncan, is actually encouraging. It's exactly what we want to see at this stage. Now, there's another factor that makes these cases particularly interesting, and that's the statement that Justice Kavanaugh made when the Supreme Court denied review in Snope. In his statement, Justice Kavanaugh essentially said that the time is coming very soon when the Supreme Court will need to take up the assault weapon ban issue and resolve this question. He indicated that this could happen in a term or two. Now, that statement was significant because it showed that at least one justice, and likely more than one, is ready and willing to take up this issue. Justice Kavanaugh was essentially sending a signal to the lower courts and to litigants that the Supreme Court is aware of this issue, that they know it needs to be resolved, and that they're going to address it in the near future. We have to talk about the shift happening with the middle justices. Justice Kavanaugh and Justice Barrett have been the wait-and-see votes. But something changed in late 2025. We started seeing statements attached to denials of cert. These aren't just notes, they are signals. Kavanaugh's recent statement regarding the Maryland case was a flare sent up to every pro-Second Amendment lawyer in the country. He essentially said the record in this case wasn't perfect, but bring me the right one, and we are ready to go. That right one is what is being pushed forward right now. So the question is, are Vamonte and Duncan the cases that will fulfill Justice Kavanaugh's promise? Are these the vehicles that the Supreme Court has been waiting for? The plaintiffs in Vamonte are certainly making that argument in their petition. They're essentially saying to the Supreme Court, you promised you would take up this issue. We're giving you the perfect opportunity to do that right now. Here are two cases, one dealing with rifle bans and one dealing with magazine bans, that present these questions cleanly and clearly. Take these cases and resolve these issues once and for all. Now, I do want to address the arguments that Cook County has made in response to the petition in Vamonte, because it's important to understand both sides of this. Cook County filed a brief in opposition to the petition, and they made several arguments for why the Supreme Court should deny review. First, they argued that there's no circuit split on this issue. In other words, they claimed that the federal courts of appeals are not divided on whether AR-15s are protected by the Second Amendment. They said that multiple circuits have upheld assault weapon bans, and that there's no conflicting decision from another circuit that would require Supreme Court intervention. Now, this argument is somewhat misleading. While it's true that multiple circuits have upheld assault weapon bans, the reasoning that these circuits have used has been all over the map. Different circuits are applying different tests and coming to these conclusions for different reasons. And more importantly, many legal scholars and gun rights advocates believe that all of these circuits are getting it wrong and that they're not properly applying the Supreme Court's directives from Heller and Bruin. So even if there's not a traditional circuit split, where one circuit says assault weapon bans are unconstitutional and another says they're constitutional, there's still a need for Supreme Court intervention because the lower courts are misapplying Supreme Court precedent. Second, Cook County argued that Vamonte is a bad vehicle for Supreme Court review. They claimed that the plaintiffs failed to follow proper procedures at the district court level. Specifically, Cook County said that the plaintiffs skipped discovery, didn't present sufficient evidence, and basically rushed through the lower court proceedings in an effort to get to the Supreme Court as quickly as possible. Cook County is essentially arguing that the case is procedurally defective and that the Supreme Court shouldn't take a case with these kinds of procedural problems. Now, the plaintiffs would obviously dispute this characterization, but even if there were some procedural irregularities, the Supreme Court has the discretion to take a case even if it's not a perfect vehicle. If the legal question is important enough, and if the Supreme Court wants to address the issue, they can work around procedural problems. And frankly, the question of whether the Second Amendment protects AR-15s is so fundamental and so important that minor procedural issues shouldn't stand in the way. Third, Cook County argued that the lower courts got it right on the merits. They said that AR-15s are dangerous weapons that are commonly used in mass shootings and that the government has a compelling interest in banning them. They argued that the Second Amendment doesn't protect these weapons and that the Seventh Circuit's decision was correct. Now, this is obviously the heart of the disagreement. The plaintiffs believe the Second Amendment absolutely protects AR-15s. Cook County believes it doesn't. And that's exactly why the Supreme Court needs to step in and resolve this question. So where does all of this leave us? We have two cases, Vamonte and Duncan, that have both been relisted for the Supreme Court's next conference. At that conference, the justices will once again discuss these cases, and we'll find out shortly after that conference whether the Supreme Court has granted review, denied review, or relisted the cases yet again for another conference. If the Supreme Court grants review to one or both of these cases, that would be absolutely massive. It would mean that within the next year or so, we would have a Supreme Court decision on whether the Second Amendment protects AR-15s and standard capacity magazines. And based on the Supreme Court's conservative majority, and based on what the Supreme Court has said in Heller and Bruin, there's a very real possibility that the Supreme Court would strike down these bans. When we talk about a permanent end, we aren't talking about a new law. We are talking about a categorical ruling. If the Supreme Court takes up a case like this and rules in favor of the Second Amendment, they won't just look at one state. They will likely rule that semi-automatic firearms, by virtue of being in common use, are a protected class of arms. Once that happens, every assault weapon ban in America from Seattle to New York City dies instantly. They become unconstitutional on their face. No more grandfather clauses, no more registration, no more featureless builds. That would effectively end assault weapon bans and magazine bans across the entire country. States would no longer be able to ban AR-15s or standard capacity magazines. That would be a monumental victory for gun rights. On the other hand, if the Supreme Court denies review, that would be a significant setback. It would mean that these bans remain in place, at least for now. It would mean that states like Illinois, California, New York, and others can continue to ban AR-15s and magazines. And it would mean that we'd have to wait even longer for the Supreme Court to address this issue. But here's the thing. Even if the Supreme Court denies review this time, that doesn't mean the fight is over. There are other cases in the pipeline. There are other challenges being filed. And eventually the Supreme Court is going to have to address this issue. Justice Kavanaugh said as much in his statement in Snope. The question is just whether it happens now or whether we have to wait longer. Now, one thing I want to emphasize is that we need to be realistic about the timeline here. Even if the Supreme Court grants review to these cases, we wouldn't get a decision until probably June or July of next year. That's how the Supreme Court's process works. They grant review, they schedule oral arguments, the parties file briefs, the justices hear oral arguments, they deliberate, and then they issue a decision. That whole process takes months. So we're not going to have an answer tomorrow or next week. This is going to take time. But the fact that we're even at this stage, the fact that these cases have been relisted and are being seriously considered by the Supreme Court, is significant progress. I also want to talk about what this means for gun owners in states that currently have assault weapon bans and magazine bans. If you live in a state like California, New York, Illinois, Maryland, Connecticut, or any of the other states that have these bans, what should you do right now? Well, first and foremost, make sure you're complying with your state's laws. I'm not telling anyone to violate the law, but second, stay informed. Follow cases like Vamonte and Duncan. Understand what's happening at the Supreme Court. Because if the Supreme Court does strike down these bans, that's going to create opportunities for gun owners in these states to finally exercise their Second Amendment rights fully. And third, support the organizations that are fighting these cases. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, and other groups are the ones funding these lawsuits and pushing these challenges forward. They're the ones doing the heavy lifting. So if you believe in the Second Amendment and you want to see these bans struck down, support these organizations, become a member, make a donation, help them continue this fight. This is a critical moment for the Second Amendment. This could be the case that finally ends assault weapon bans and magazine bans across the country. Or it could be another disappointment where the Supreme Court once again punts on this issue. But one thing is certain. The fact that these cases have been relisted shows that the Supreme Court is paying attention. They're considering these issues, and there's a very real possibility that they're going to take action. As we get more information, as these cases develop further, I will absolutely keep you guys updated. This is one of the most important Second Amendment issues of our time, and we're going to follow it every step of the way.